All right, Austin Gibson. So the last time we were here, on September 29th, he pled not true to violations 1 and 1. So is that still the case?
No, Your Honor. My client wishes to change his plea to true to both the allegations.
All right. So we're going to go on the record. The court is calling 2019 CR 8096 State versus Austin Zachary Mark Gibson. Can I have parties announced for the record for the state?
Lauren Espinoza.
Andrew Fraley to the defendant.
And are you Austin Zachary Mark Gibson?
Okay, pause here. Did you catch that quick pivot? We opened with routine roll call energy, but underneath, this isn't routine at all. Austin Gibson was on deferred adjudication for aggravated assault with a deadly weapon, a legal tightrope where one wrong step drops you straight into conviction. Moments ago, we heard pled not true. Now there's a shift coming. The state is about to read fresh violations. The stakes are lethal for a defendant on deferred, one credible violation, and the judge can pull the ripcord, find guilt, revoke, and sentence within the full range. Here's your hook. Does Austin's explanation meds, heat, a busted car sound like mitigation or convenient chaos? Keep watching, because the contradictions, the letter from his wife, and the judge's memory of prior chances collide into a decision that stuns. Before we get there, what would you do in this judge's seat, mercy again, or hard line? Tell me below.
Gibson?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Austin Zachary Mark Gibson who was placed on deferred adjudication in 2019 CR 8096 for the offense of aggravated assault with a deadly weapon on February 21st, 2020 for a period of 7 years? Is that you?
Yes, Your Honor.
All right, state.
Violation of condition number 1 means a new offense while on community supervision. The state lists criminal trespass and criminal mischief, $750, $2,500. That dollar band matters because it elevates the charge level. Why it's explosive. On deferred adjudication, you're already convicted in waiting. Admit a new law violation, plead true, and you unlock the judge's power to adjudicate guilt on the original aggravated assault. Ask yourself, does the described conduct, jumping a fence, damaging property, fit trespass and mischief? On paper, yes. The nuance is intent and credibility. Was he truly looking for water to salvage a failing car, or disregarding boundaries and property? Drop your read, honest scramble, or reckless choice.
Your Honor, violated condition number 1 on or about the 31st day of August 2025 in Bexar County, Texas. The defendant, Austin Zachary Mark Gibson, committed the offense of criminal trespass in violation of condition number 1.
How do you plead to that?
True.
Violated condition number 1 on or about the 31st day of August 2025 in Bexar County, Texas. The defendant, Austin Zachary Mark Gibson, committed the offense of criminal mischief greater than or equal to 750 less than 2,500 in violation of condition number 1.
How do you plead to that?
True, Your Honor.
Did you understand by pleading true to violations 1 and 1, the court could find it true, grant the motion?
By pleading true, the court can find the violations, grant the motion, enter adjudication, and sentence up to 20 years plus a fine. Translation: this is not a minor slap. This is a door opening to the full punishment range of the original aggravated assault with a deadly weapon. Viewers, would you ever advise a client to plead true here? Sometimes defense goes true to preserve credibility, seek mercy, or avoid a contested hearing that could look worse. But it's a calculated risk. You're conceding the violation and banking on judicial leniency. Smart move or Hail Mary? Comment your verdict.
Find you guilty, sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of conditions 1 and 1?
Yes.
Court will find violations of conditions 1 and 1 true. State, what are you recommending?
Your Honor, at this time, state is recommending that you grant state's motion to revoke, enter an adjudication of guilt, and sentence to 7 years in the prison.
And defense, what are you requesting?
State comes in firm, revoke, and 7 years. Defense asks to continue and lets Austin address the court under oath. That's allocution, the human moment where a defendant can own mistakes, explain context, and propose a path forward. Judges pay attention to specifics, mechanisms for treatment, stable employment, verifiable plans. This is where tone and detail matter more than theatrics. For creators, great place to add on-screen bullet points, treatment history, sobriety dates, employment offer, so viewers track mitigation versus new harm. Question for you: when the state anchors at 7 years, is that a reasonable midpoint, or a signal that patience is thinning?
Judge, we're requesting continue. My client would like to address the court.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Austin Mark Gibson.
All right, so what do you wish to say to the court?
I just want to tell you that I do accept a full range of, full responsibility for it all, and I do apologize to you in the court, and the persons of that business. I did react like this due to, lack of consistency on my medication.
Early work hours, missed doses, phone issues, a toddler who grabs the phone, life friction that, frankly, many viewers will recognize. Legally though, mitigation isn't absolution. Courts want proof of structure, pillboxes, alarms, pharmacy blister packs, caregiver support, documented clinic contact. He references CHS and an appointment with Amanda Good, but judges ask, did you keep it? Did you update probation? Hybrid take, empathy for the struggle, skepticism for the system's gap. Audience check: if someone stops meds and then breaks property during a spiral, should the response be treatment first or sanctions first? Where do you land, compassion or consequences?
I do ask that I can get the help to get this correct. I have a meeting scheduled with Miss Amanda at CHS.
I apologize. I'm going to ask a couple of questions and go back. Before we talk about Amanda from Center for Healthcare Services, talk about what happened. You said you were inconsistent on your medication.
Yes.
You want to be more specific?
A lot of the inconsistencies would be, getting up very early for work, like 3 a.m. I wouldn't, out, just pack my lunch and out the door. Being there's time that my phone isn't charged or plugged in, or even the noise, because my little girl would like to grab my phone.
And so you basically stopped taking medication.
Yes.
And ever since you got clean and sober, when did you get sober?
I've been sober for a good while.
Ever since you got out of Lifetime, pretty much?
Yes.
With one minor exception, but you've tested negative on your UAs since October of 2024.
Sober since release from Lifetime. UA's negative since October 2024. Completed inpatient and outpatient, even SATA before that. That's not nothing, it's hard-won progress. Then the dent, delinquent fees, but he's secured a second-chance employer. Judges love verified employment. It means structure, accountability, restitution potential. But here's the tension: the system can applaud sobriety and still sanction new criminal conduct. This is the moral math of probation, past progress versus present breach. Craft your sentence in the comments. If you're the judge, do you extend probation with strict mental health compliance or adjudicate and cap risk?
Basically, for the last year, you've been all negative on all your UAs.
Yes.
And you successfully completed Lifetime Recovery inpatient.
Yes, sir.
Successfully completed SATA before that.
Yes.
You had done the outpatient program before.
Yes.
Completed your UAs in the last year successfully. Done private outpatient with Lifetime, is that correct?
Yes.
And you're behind on your fees though, is that correct?
Yes. But I do have employment.
Yeah, but go ahead.
I do have employment that I can catch that up. I did have a vehicle that had a lot of issues, and it took a lot of my money, and that's why I couldn't stay consistent on the payments. But this job that I do know is a second chance employer. They have accepted me for employment.
And so since you got off your medication, that's the real problem you're having.
Yes.
And what happened with this specific incident?
It was just time of day. It was
Heat, frustration, broken fence, climbing a bank roof, hunting for an HVAC valve, then kicking piping by accident. For trespass, the elements are entry without consent. For mischief, it's intentionally or knowingly damaging property, with value brackets driving severity. Here, the narrative tries to frame necessity, radiator, water, and lack of malicious intent, but property owners and courts see boundaries and risk. The roof scenario is a credibility trap. If it's truly about water, why escalate from fence to roof to valve? Prosecutors love this. Each step looks more deliberate. Viewers, is this resourceful survival or reckless entitlement?
Hot, I just got frustrated. I outlashed towards just an inanimate object rather than a person. And, broke the fence, and I was looking for water for my radiator because I thought it was the radiator that had failed, but it was the water pump. So I tried to put water into the reservoir so that it could feed back into the radiator, but I didn't find nothing but like maybe a quarter of a cup.
So, but what happened was you were trying to fix
Yeah,
that.
I wanted to fix that, and I couldn't find a water faucet that worked. So I said, oh, you know what? I already broke the fence. Let me go to the roof. Let me see if I can find a run valve for the HVAC system. Well, I found one. I tried to turn it, and it didn't work. So when I stood up, I slipped and I kicked the piping right there.
And what does that have to do with you being off medication? Talk to the judge about that.
That's just me. My mood swings have been. It's been a lot of up and down, and I never really understood how to talk to anybody about that. I would like to try to talk to my team there at the Center for Healthcare Service, but when I do call, a lot of the numbers, either when I call they answer and hang up, or it sounds like a fax machine, like a beep boop beep boop boop.
I have a question.
Yes, sir.
Prior violation, Hashone was a 2023 assault. The complainant is his wife, Claudia. That motion was withdrawn, conditions amended, treatment ordered. Defense now waives a letter noting medication issues. Key legal insight: a withdrawn motion isn't exoneration, it's a procedural retreat that often comes with stricter conditions. For a judge, this creates a pattern: prior violence at home, new property crime in public, repeated medication lapses. In hybrid tone, the court's patience reservoir is shrinking. Engagement prompt: does a supportive spouse letter help, or does it sometimes trigger protective instincts from the bench, especially with minors in the home?
You've been before me previously for a violation of condition number 1.
Yes.
And whenever there's a violation of condition number 1, that's a new charge. So what was your previous violation of condition number 1 for?
I can't recall.
All right, could somebody look that up and tell me what that previous number 1 was? Because once you had a violation of condition number 1 for that time, the court denied the motion, and that's when you got sent to lifetime recovery. And the motion was withdrawn. So there was a previous number 1. Yes, what was the previous number?
In 2023, the new offensive assault was withdrawn on 2023, and conditions were amended to include drug court, lifetime recovery.
All right. So that was an assault. And who was the complainant in that assault?
That was my wife,
The name?
Claudia. Rushing.
Yes. And now I have a letter, defense exhibit number 1, with her saying, there were some issues between you as far as you're not doing your medications.
Yes.
All right, continue. I'm just trying to get the sequence of events in my head, all right?
And it's just been there's not much else I could say about it. It's just, I've had a lot of, problems within myself trying to find, either courage or, cry out. I'm not sure, but I didn't know that I could even come to you. A lot of people told me in the jail that I could ask you.
No,
for the
because
help
let me
too,
just
but-
tell you, let me stop you right there. You're saying that you can't come to me? I
No,
don't believe that. And let me tell you why I don't believe that. And your counsel will tell you this. Everyone in this court who is placed on probation, I let them know. If they have an issue, let their officer know. If they feel as their officer is not addressing it, then you can come back to me. And every time that somebody's had a motion to revoke, if I've continued them, I tell them that. So don't start with, I didn't know I could come, because that's not true.
Yes. Yes. And my plan is to get with Miss Andrea at Center for Healthcare Service, and explain to her my, issues that I've had personally, and see who she could get in touch with, like with the care team over there that I can follow through with.
Austin, if I could interrupt you, you met with somebody 2 weeks ago from Center for Healthcare Services since you've been in custody, is that correct?
Yes.
But when you met with her, she talked to you about if you're released, if the judge is kind enough to continue you, you can go to Center for Healthcare Services.
Yes.
And they will plan a treatment and care team around you.
Yes.
That's what you told me.
Yes, they will.
So it's not so much of, you're gonna talk to her when you get out, but you've actually met with her and.
Yes, and she's told me and 4 other gentlemen that they would do that.
And so what you're asking the court to do.
And I'm asking the court if you could kindly reinstate, if not, I accept the full range of the punishment of my problems here.
All right, state any questions?
Briefly, Your Honor. Mr. Gibson,
Did he notify probation about med inconsistency? Did he contact CHS? Then the water detail, empty bottle versus 2 jugs, plus pouring hot water on himself. These aren't trivial contradictions, they're credibility fractures. In sentencing, judges care less about perfect recall and more about consistent responsibility. If facts wobble, mitigation collapses. Strategy note for defendants: when the state goes granular, own what you can verify and don't over-explain. Viewers, your call. Did the cross reveal honest confusion or shifting story? Type confusion or shifting below, curious where you stand.
at any point during this inconsistency you refer to, did you inform your probation officer?
Say again?
At any point during this time of inconsistency, did you inform your probation officer of that inconsistency?
It's been she's a very hard woman to get a hold of to start with. So, I mean, I would like to talk to her. Like I would want to tell her things like that, but she would always say like, no, that's not for me to deal with.
But my question is, did you make attempts?
Yes.
Okay. And then prior to August 31st, 2025, did you have contact with Center for Healthcare Services regarding this inconsistency? Or did you make attempts to?
Yes.
Yes. You mentioned that you were attempting to get water, correct?
Yes.
On or about August 31st, 2025, was the Wallace Bank open?
No.
Were there
I
other
don't think-
businesses around?
There was a Jason Deli, I believe, but I had asked somebody like from the parking lot, like, hey, can you help me with some water? They looked at me like I was crazy, so I was like, I'm not even gonna attempt to.
Would you agree with me when you jumped the fence for the Wallace Bank, you had 2 jugs of water with you?
No, I had an empty bottle.
So at no point you didn't pour water on yourself throughout the
I
time?
poured water on myself, yes, but it was that was very hot water.
So you would agree you came? to
Yeah,
the Wallace Bank with
yes,
water?
with water, yes. But I needed more water.
Mr. Gibson, would you agree with me the best way for someone to learn a lesson about consequences for them to take full responsibility for their actions?
Yes.
No further questions.
Nothing further.
All right. So probation, on this case, can you tell me, was there any restitution that was due Vincent Arias and Victor Toro? All right. So, Mr. Gibson, what I can tell you is I read the letter from Miss Rushing.
There's nothing else I can do. That's judicial code for exhausted alternatives. We hear a timeline 2020 violation true, treatment referrals, a withdrawn motion, drug court, lifetime recovery, SATA. This is the progressive sanctions ladder. Try rehab, structure, therapy, until public safety risk outweighs rehabilitation hope. Legal decoder: once the court finds the violations true, it can revoke and adjudicate the 2019 aggravated assault, no longer deferred, now a final conviction. This is the moment viewers often call harsh. But in supervision land, it's inevitable math, multiple chances, new law violations, credibility doubts, minors potentially exposed. Do you agree?
There is nothing else I can do to help you. And let me explain to you why. This is not your first motion to revoke. And each motion to revoke that you've had with me has been your having a new case. So the first time, you're of course on deferred adjudication for aggravated assault with a deadly weapon. And the first time was an assaultive case against, you say, your current wife. And that motion was withdrawn. I'm assuming it was withdrawn because maybe she didn't want to come forward, or maybe there wasn't enough evidence. I'm not saying either way. I'm just saying that with regards to that, that issue was addressed by withdrawing the motion. And when that motion was withdrawn, the first thing was a referral to felony drug court. And if you were not accepted there, a referral to lifetime recovery. And before that, you were sent to SATF. So there is, and then, well, actually, you've had more than one motion to revoke. So you had a motion to revoke in 2020. That was a violation of condition number 1. The court found that true after your plea of true. You were denied an alternate amended with a TAP evaluation follow recommendation. Then on November 2020, you're like, hey, I'm ready for treatment. Let me do it. And I said, okay. And that's when you were with your new wife, and there was supposed to be no harmful or injurious contact with her. And then after that happened, then there was a motion to revoke that was withdrawn, and they alternately amended conditions to include no contact with Claudia Rushing. And here we are with another number 1. And based upon the state's cross-examination and your answers, this wasn't about your seeking water. You had 2 jugs of water, and you actually poured water on yourself instead of pouring it in your vehicle. So as previously stated, the court is finding 1 and 1 true. The court is going to find you guilty. The court will revoke you. There's an affirmative finding of deadly weapon. There's to be no residing.
The court finds 1 and 1 true, revokes, adjudicates, and flags an affirmative deadly weapon finding on the underlying case. That designation isn't cosmetic, it can affect parole eligibility and program placements. Then strict conditions: no residing in a household with minors, no unsupervised contact with minors, and no contact with Claudia. Names like Vincent Aris and Victor Tovar surface for restitution context. Finally, the hammer: 10 years in prison, with credit for time served, and a recommendation for therapeutic community, a treatment track inside custody. Hybrid read: accountability with a thread of rehabilitative intent, fair balance, or too late for treatment.
In any household with minors,
Why is that?
there is to be no unsupervised contact with minors. And the court is going to have the previous conditions that were previously given. There's to be no contact with Claudia Rushing. Vincent Arias. And Victor Tovar. I think it's Tovar, Tovar. And the court is going to sentence you to 10 years in the prison. The court will give you credit for any time served, credit for any time served for successful completion. Thank you. All right, if you'll let the clerks know. Successful completion of inpatient treatment. Court will recommend therapeutic community. Therapeutic community doesn't increase the time that you're in custody. It's just to provide you with help with your sobriety. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it? All right, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication.
Austin pleads for contact with his wife and daughter. The judge cites the letter indicating the household's minors may not be his biological children, plus prior assault history, and keeps the no contact and no unsupervised minors rules. Defense asks to allow contact with his biological daughter. The court limits it to no unsupervised. Here's the larger doctrine: in criminal court, public safety and child welfare trump nostalgia and promises. Family contact must route through supervised channels, think CPS, family court orders, or approved custodians. Engagement question: should biological parent status soften restrictions after repeated violations, or do patterns speak louder than DNA?
Quick question.
Sure.
That my wife is all I have up there, and I understand that, you know, what I did was wrong, but she's the only person I have.
So
out there.
here's the thing. I understand what you're telling me, but what I'm telling you is based upon the allegations of your previous assault against her. You all agreed that the motion would be withdrawn, and this is from 2023, I believe. You agreed that it would be withdrawn and that there be no contact with her. So the court is following the previous condition.
Please let me at least talk with her, because that's my daughter, you know. That's my family. That's all I have.
No, in the letter that I received, she states in that letter that those are her biological children, not your biological children, that you have a biological child with someone else.
Oh, it's with her.
No, that's not what's in the letter.
With Claudia?
Yeah.
Yes, I have a little girl, Athena Gibson.
That's
with
not
her.
what she put in the letter.
Yes, I have a biological daughter with her, Your Honor.
Well, what I'm telling you is when you're released, you're not allowed to have any contact with her. When you're at the prison, you're not allowed to have any contact with her. You're not allowed to have any unsupervised contact with minors, and you're not allowed to reside in any home where there are minors. And that's based upon the letter that was presented to me. That's based upon your current actions.
And Judge, could we modify that to allow him to have contact with his biological daughter?
No unsupervised contact with minors. All right, thank you. So sometimes you can only do what you can do to help people. And when people are placed on probation, your goal, once they're placed on probation, is for rehabilitation. And then at some point in time, there's nothing else that you can do. And many times when I do no residing in household with minors is because there are issues with him. Now, the letter that was presented to me to read, in that letter, she says he's off his medication. Sometimes he's violent. Then why is he living in a household with the children when he's not on his medications? And so that's a danger. And part of my duties is, yes, I can place people on probation, but if they're going to be on probation, I have to craft conditions that will protect the public. And many a time, for example, he's going to prison for aggravated assault with a deadly weapon. He has drug issues. He has, violent tendencies. There's going to be some woman in the world who's going to think he's a great catch, and they're not looking after their children. For example, his previous case where there was a new number one, that was involving the lady that he's saying, oh, I need to have contact with her. And in the letter I read, there was so much in there where he should not be having contact with her, but she's still making excuses for his behavior. And then when you have children who grow up around that, they think that that's normal. And so if they believe that the father or the mother loves their spouse, right? And they're being violent towards them, then they tend to think that's how you show you love somebody. So I do my part. All right, Ronnie Demas.
Austin Gibson entered on deferred adjudication for aggravated assault with a deadly weapon. After admitting 2 new violations, criminal trespass and criminal mischief, the court weighed a history of treatment chances, sustained sobriety, and employment promise against credibility gaps, a prior assault motion tied to his wife, and risk to minors at home. The judge found the violations true, adjudicated guilt, imposed 10 years imprisonment, barred residing with minors, banned unsupervised contact, and prohibited contact with Claudia, while still recommending therapeutic community for rehabilitation inside. Takeaway: rehabilitation matters, but public safety and pattern recognition decide outcomes when probation breaks. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Judge, good morning. May I approach the bench?
Yes. And Ted Wood he does criminal cases as well as child protective services cases, and he does treatment court as well. So he'll be able to tell you the things that he's seen on CPS side and about adults not making great choices for their children.
Which, just by the way, the court's edification, felony drug court is like the highlight for me.
Yes.
Because I get to watch people check you.
Oh, yeah, felony drug court is great. I remember I started out as one of the original attorneys of felony drug court. And when we started, we would chase people down, be in this program, and then we would pick them up and take them to rehab. So it was great. Yes.
I'm here on Mr. Dean's, Judge. As you'll see to my left and to my right, I'm standing here alone.
Okay.
He called my office, and I believe he called your one of your clerks and informed my office and your clerk that he was in the hospital. I called him back, the number he left him a message saying, you need to bring documentation, because if you don't, it's not going to go well for you.
Yes.
So,
All right. So, if you know what hospital he's in, you're an officer of the court. If you reach out to the hospital and call them and they say he's there, then, I will take that. But just his saying it, no. So I'll give him till 11:30.
very well, Judge. May I be excused?
Yes.
I gotta go to some other courts. I'll reach out to him on the phone, see if I can get him again. Okay, and I'll report back to the court.
All right. Thank you. All right. Emmanuel Gonzalez. Hello, Mr. Gonzalez. All right. Yes. All right. They're saying that they're dismissing your case because the complainant doesn't want to go forward and the complainant is waiving prosecution. This is what I'm going to tell you. Oh, do you have any objections to the court signing this?
No.
All right. Sometimes people have objections. And so this is what I'm telling you. Complainant waiving prosecution, that doesn't mean that the state is saying they don't have any evidence for this to go forward. It just means that the complainant has said, I don't want to go forward with this. So whatever issues that are developing between you and this complainant, maybe that is a person that you all should not get to be together. If there's some kind of anger issues that are going on, you need to take care of that, because otherwise, you know what's going to end up happening? You're going to be right back here.
Yes, sir.
Yeah. Thank you for dressing appropriately for court. Yes. Thank you. All right, Christian Garza. Oh, you heard.
Just giving you a heads up on this one. We had filed a motion to reduce bond. I've spoken to the state. Other factors have come up. We are withdrawing the motion.
All right, so we'll go on the record. The court is called 2025 PF 35204, State versus Christian Garza for the defense.
John Pettis.
And are you Mr. Garza? All right, and defense, you have a motion for bond reduction that has been filed. And what is the status?
We're withdrawing that motion.
All right, then the motion will be withdrawn. Is there anything else?
No, Judge.
All right, thank you.
Thank you.
So basically, what that means is sometimes, for example, they were asking for a bond reduction. There may be some more information, or it could be maybe he has other cases that are coming down or pending. But once the defense has conferred with the state, they decided they don't want me to hear the motion to reduce bond. And so they withdrew it. Now, just because they withdrew the motion doesn't mean that they can't come back and refile it and ask for it later. But for now, we're not going to hear it. Jonathan Carter? Hello, I'm doing great. So, state, did you tender an offer?
We did, Judge. We'd actually had a prior offer and then I gave a new offer this morning after negotiating with defense.
All right.
Time to go over that with the employer and everything like that, Your Honor. I don't believe it's either party's intention to take this thing to trial. We're not trying to drag this thing out. We just need a little bit more time.
All right, Ms. Ferguson. Set this for October 16th. That's your final plea deadline date.
Yes, sir.
All right, once you sign the reset form, you're excused.
Yes, ma'am.
Thank you.
Yes, ma'am.
Thank you, Judge.
Thank you. All right, Jesus Suarez Marino. So this is a motion. He's requesting a bond reduction. His next court date is October 20th, and that's for discovery. All right, the court is calling 2025 CR 007922, State versus Jesus Suarez Marino. I believe this is family violence.
Yes,
All right, could I have parties announced for the state? Defense?
I'm here by the end of the.
And are you Jesus Suarez Marino?
Yes, ma'am.
All right, so his current bond is set at $125,000. What are you requesting for the reduction of bond?
Well, Judge, I think 50,000 would be fair.
All right, so you're requesting 50,000. And state, are you going to be opposed to the reduction?
Yes, we are, Your Honor.
All right, defense, do you have any evidence?
I do, Judge.
Yes.
But my witness is unavailable today, so I will need to withdraw the motion or reset it for another day.
All right, when will your witness be available?
I have to get a hold.
All right, so what we can do, is your witness able to appear by Zoom?
Okay.
All right, are you going to object to their witness appearing by Zoom?
No objection.
All right, so if you'll speak with Ms. Ferguson, and that way we can take care of it today. If you feel more comfortable with them being in person, just let us know. We can reset it, or otherwise they can appear by Zoom.
I would prefer to reset it, Judge.
All right, so Ms. Ferguson, this motion will be withdrawn, and we're still on the record, correct?
Yes, ma'am.
All right, so defense, are you withdrawing the motion to reduce bond?
I am, Your Honor.
All right, the motion will be withdrawn. Thank you.
Thank you.
You're welcome.